the hands of his lawyers.
Those are the claims outlined in a lawsuit against 10th Circuit Solicitor Chrissy Adams and the Oconee County Sheriff's Office. So tonight, 7 News reporter Brianna Smith is here digging into the lawsuit. She's joining us right now with the very latest on this. Tell us about it.
Can you imagine if you were charged with a crime and the evidence was there to clear you? After being charged, the teen was kicked out of school and couldn't finish high school for nearly 2 years. When DNA evidence made available almost immediately could have cleared his name. And that teen's lawyer is now alleging gross negligence by the two officers that should have protected him. In 2013, an Oconee County's teen life was turned upside down, charged with criminal sexual conduct. Soon after that, a DNA test in the case was sent to be tested by SLED, and the teen's lawyer filed a request to see the results of that test and all other documents in the case as they were given to the sheriff's office.
We filed a discovery request in November requesting specifically for all the discoverable evidence. Anything they had in their possession or could get in their possession to turn it over.
Lawyer Keith Denny says the sheriff's office got those results of that DNA test in January of 2014, but it wasn't given to him until over a year later. A year spent arguing the teen's innocence that could have been proven sooner with the results of that DNA test.
It showed explicitly that any DNA they collected didn't match him. They could not tie it to him. Now, that's just one piece of evidence that they withheld. There was medical reports specifically contradicting what they alleged in their petition to arrest my client.
The lawsuit says both the sheriff's office and the 10th Circuit Solicitor Chrissy Adams should be held responsible. That's because both agencies should have been aware of the evidence. Adams' attorney filed a motion saying she should be immune to the lawsuit, but the judge denied it, a decision that was refreshing to this hometown lawyer.
The solicitor's office has a higher standard. They're to seek justice. That means if they have information that would exonerate someone, they must bring it forward.
And hopes that this lawsuit not only helps this teen, but helps future cases in Oconee County as well.
And I appreciate what they do. I really do. But when you have a couple or a specific investigator or a specific process that's in place that is so contrary to the administration of justice, so contrary to our values, that's got to stop.
We are told that the solicitor and the sheriff, along with the lead investigator that is named in that suit, is going to be deposed in this case soon. So as soon as that happens, we're going to get a lot more details in this case.
So Brianna, a motion for discovery, a motion to have a look at the evidence in a case is a pretty routine thing.
Typical.
How about the solicitor and the sheriff? Are they saying anything about how this evidence could have sat there somewhere for a year?
Well, I asked them both in this case about if they could comment on the case. Of course, pending litigation, they are not going to comment. I did ask the sheriff loosely if he would tell me, what happens in your evidence process? Do you turn it over right away? When is that turned over? He said, I can't speak on anything in that right now. He believes, though, if this lawsuit goes forward, that all the evidence will clear his deputy and his name as well.
Hopefully answers and all of that soon. Brianna, thank you.
Thank you.